Today's podcast includes commentary from a guest speaker. Neither the RIA Compliance Collective nor RIA Compliance Concepts is affiliated with the speaker or the company he or she represents.
Whether your advisory firm has 1 or 5 people, compliance will always be an issue. RIA Compliance Concepts is more than just another service provider. We truly care about seeing our clients prosper. That's why we started our podcast, the RIA Compliance Collective, providing up-to-date compliance guidance. We're passionate about doing our job so you can focus on doing your job. We understand regulatory compliance like the back of our hands, from full-service RIA registration to annual compliance reviews and everything in between. We're here to get you there.
Hey everyone, welcome back to the RIA Compliance Collective. Ivan and I have a special guest for you today as we want to discuss a topic that keeps coming up in conversations with our clients. Whether it's a new firm going through a registration process or an established RIA, we're seeing more and more advisory firms wanting to offer some sort of retirement plan consulting service. Wouldn't you say that's right, Ivan?
Yeah, in the past year and a half, 2 years now, we're getting more and more clients that are interested in getting into this space, basically, because they're dealing with a lot of smaller clients that are starting businesses and wanting to offer a 401k plan to their employees. And so it basically ties hand in hand with what they're doing for their clients. So they're getting asked more and more with more smaller businesses that are starting up, being asked to start engaging in this kind of venture. And so we decided that we wanted to put a podcast together with help from Vestwell and their team to help navigate some of the questions that most of our clients are asking.
Here today to discuss this topic is Allison Brecher. Allison is the general counsel at Vestwell, which is a digital platform that makes it easier to offer and administer retirement plans. Allison leads the legal, compliance, and data privacy operations there. She's practiced in the ERISA, employee benefits, and privacy areas for more than 20 years and enjoys using her expertise to educate plan sponsors, advisors, and others about the legal and compliance issues involved with operating their retirement plans, which is exactly why we asked her here today to give us and you basically a Fiduciary 101 class, if you will.
With that being said, Allison, what are the fiduciary duties for ERISA and how does this apply to advisors?
Well, fiduciary duty is really the highest standard under the law in the United States, but not many people know what it really means. And, we throw around that term kind of flippantly sometimes, but it really boils down to 3 things, Ivan. It's the duty of loyalty, the duty of prudence, and the duty to act solely in the best interest of the plan and participants. So let me break that down a little bit. So first, the duty of loyalty. What that's really getting at is all about conflicts of interest and making sure that your service providers, if you're the plan sponsor, making sure that your service providers are disclosing those conflicts of interest so that they could be managed properly. So one easy example of a potential conflict of interest is when a service provider acts as a record keeper and also offers proprietary funds as part of the lineup and bundles the two together. I'm not suggesting that's always a conflict of interest, but it certainly has to be disclosed because it has the potential to be one. And there's lots of litigation right now all across the country, really based on that kind of theory that there's been a breach of the duty of loyalty. The duty of prudence really comes down to reasonableness and making sure that your service providers are adding value to the plan and that they're being paying a reasonable fee. Reasonable fees don't have to be the least expensive fees. The DOL is very clear about that, but they do have to be reasonable. And so it's important to just make sure that you are vetting your service providers, that you are benchmarking them if that's appropriate to make sure that their fees are, sort of within the range of the industry. And then last but not least, the duty to act solely and exclusively in the best interest of the plan and participants. That's also called the exclusive benefit rule. And again, each word you should really take pretty literally there. The plan sponsor has the fiduciary duty to make sure that it and all other plan fiduciaries are acting solely in the best interest of the plan and its participants. So one way that could come up is, let's just say, for example, that a service provider said to a plan sponsor that it will be providing record keeping or some other services. And by the way, if the plan sponsor opens up its own bank account at a bank, so that's sort of affiliated with the record keeper, that it could get a discount. That's an example of something that would probably be seen as a breach of the exclusive benefit rule, because the plan fiduciary is not acting solely in the best interest of the plan and its participants. So I hope that helps.
No, thank you very much for the clarification. We always get questions about this as far as fiduciary responsibilities when you're working with plan sponsors. So one of the questions that we commonly come across is how and to what extent can a plan sponsor delegate away its fiduciary responsibilities?
Well, contrary to what people sometimes think, and I get questions like that as well, a plan sponsor cannot completely delegate away every one of its fiduciary obligations. It always continues to act as a fiduciary in some form. So some plan sponsors, especially, and those who are new to the space, may think that if you just delegated all of these responsibilities to service providers, that the plan sponsor can essentially wash its hands clean and make sure and just know that these service providers are providing all of the fiduciary obligations. That's not true under the law. The law and recent cases are very clear that the plan sponsor always retains some level of fiduciary duty. And one way to think about this, Ivan, is that fiduciary duty under the law here is all about like a functional test. So in other words, the saying, if it walks like a duck and acts like a duck, it is a duck. So that's really the test here too. No matter what is written in a contract, and lots of service providers will go out of their way to disclaim any kind of fiduciary duty. But if they're taking on some level of discretion regarding plan assets or the management of the plan, they are a fiduciary. And it really doesn't matter so much what they say in the contract.
That's really helpful. And Allison, you mentioned earlier litigation. There's been a lot of litigation against plan sponsors alleging that plans investments charged excessive fees or that the plan sponsor failed to properly monitor their service providers. What are some of the takeaways from this litigation, and how can plan fiduciaries prepare and defend themselves?
Well, I'm glad that you summarized the litigation, because I don't want to scare your audience or you'll never invite me back. But there are definitely a lot of lessons that everyone can learn from those cases. And just to give a little bit of background, what we're talking about here are the line of cases that have really developed in the last 10 years against plan sponsors, originally very large companies, but those defendants are changing and the plans that are involved are getting smaller and smaller. And so it's really hitting home, to a lot of plan sponsors, and as well it should be. So as far as lessons learned, it's so easy to protect yourself. First of all, under ERISA, the process of decision-making is almost more important than the outcome. So what I mean by that is that everyone, of course, hopes for positive investment returns and a successful plan and that everything goes smoothly. But the reality is that that's not always the case. Markets are unpredictable. Performance returns swing wildly from one quarter to the next. And that doesn't mean that there's been a breach of fiduciary duty. What the plan sponsors and all other fiduciaries should be doing is that they should be documenting their decision making. And that could be so easy. It could just be something as simple as an email. I realize that not all plan sponsors have a dedicated HR department or a benefits department. They're oftentimes wearing multiple hats, especially if they're a small business owner. And so all it takes is just a simple kind of written communication. Like I said, it could be an email, a memo, a note in the file some way, just something that shows that the plan sponsor or the fiduciary was thoughtful about whatever kind of decision making is involved. So whether it's the selection of a service provider or changing out the investment lineup or selecting the investment lineup, or even not changing the investment lineup when there's been poor returns, for example. Those are all fiduciary decisions, and they should just be documented. Another way that a plan sponsor can protect themselves is by setting up a committee. It doesn't have to be so elaborate. It can be 2 or 3 people at the plan sponsor, just a few people who meet regularly, and everyone just knows who's responsible. And there should just be a list of like who's doing what. Again, it doesn't have to be anything so formal or elaborate. You don't need a law firm to do this. You could just be just a really careful note taker and just keep that kind of record permanently. One other last tip that I would have, again, just a really easy takeaway from the podcast that I hope your audience will benefit from, is to make sure that your service providers have copies of the current plan documents. You'd be surprised how over time it's really easy to lose track of what are the current plan documents. There are amendments, there are loan policy statements, investment policy statements, all kind of things that just sort of come up in the process of administering a plan. And oftentimes you as the plan sponsor may forget to give those current documents to your service providers. Since those plan documents form the basis of how the plan gets operated, as you can imagine, it's really important that your service providers have them and make sure that they're updated so that they can confirm for you that they're administering the plan consistent with those provisions. So, for example, if you've recently started offering a bonus program or some kind of extra benefit to your employees like travel or moving expenses, if those forms of compensation are included in W-2 wages, they could be considered compensation, quote unquote, for purposes of the plan. That in turn affects the employer match if your plan has one. And so you can imagine how a mismatch between those two can really lead to big problems and unnecessarily added expenses for the plan. So those kind of 3 tips, really careful decision making, forming a committee if you can, documenting the decision. Again, it doesn't have to be anything so elaborate, and making sure that your service providers are constantly kept up to date with the plan documents and how you're administering the plan can really go a very, very long way to protecting yourself.
Now for a short break.
Vestwell is a digital platform that makes it easier to offer and administer retirement plans. Our solution removes traditional friction points through flexible investment strategies, streamlined administration, and fiduciary oversight, all at competitive pricing. By acting as a single point of contact, Vestwell has modernized the retirement offering while keeping the advisors, employees, and participants' best interests in mind. Learn more at vestwell.com and on Twitter @Vestwell.
And now, back to the podcast.
During the plan can really go a very, very long way to protecting yourself.
That's great. Is there any sort of fiduciary training that the plan sponsor or the fiduciary can take?
There are. You'd be surprised, but on the Department of Labor website, of all places, there is terrific training and it's free. It's called Getting It Right. It's an annual, I think, 2 or 3-part series that the Department of Labor offers free of charge. It's all online. You can subscribe to their updates so you can get informed when the next session will be. And it's really terrific because you hear from the DOL itself, the very regulator, what it's looking for when it examines plans, and you can get some really practical information. We also offer a whole host of webinars and practical takeaways, things that plan sponsors and advisors can download right off of our website and take right into a client meeting to help them prepare and set up a plan as well. And we offer those kind of webinars on a really regular basis, and we try to do them in a very plain English kind of way so that they're easily digestible and that we give really practical information that an advisor can put into practice that very day.
That's extremely helpful. I know some question we get asked often too is regarding bonding requirements.
Yeah, you'd be surprised how many times this comes up. So a lot of people don't understand the difference between an ERISA bond and fiduciary insurance. So let me break that down for you. Under the law, anyone who handles plan assets, and that's a very broad term about handling plan assets, has to have an ERISA bond. It's very inexpensive. They're easy to get. We offer a way to apply for one on our website, but you can feel free to really go to almost any insurance broker and get it. It has to be for an amount that is at least 10% of the plan assets. And it's there to protect the plan sponsor so that if there's been some kind of criminal misconduct, theft, embezzlement, or any other kind of impropriety on the plan sponsor's part that ends up damaging the plan, the ERISA bond is there to protect the participants. Fiduciary, and it's mandatory. Fiduciary insurance, by contrast, is not mandatory, but it is a good idea because that protects the plan sponsor from claims by third parties for breach of fiduciary duty, along the lines of what we were describing before, Megan, when you were talking about the litigation around excessive fees and, failure to properly oversee service providers that has led to claims around breach of fiduciary duty against other plan sponsors. So that kind of fiduciary insurance is out there to protect the plan sponsor and the other fiduciaries in the event that there are claims against them. And I should just point out one more thing relevant to your audience is that more and more often the advisor is being named as a defendant in some of these cases. So where there has been a claim around excessive fees, sometimes a group or class of plan participants are claiming that the advisor should have taken better steps to vet the investment lineup in a more rigorous fashion or more regularly review the lineup for performance and benchmarking and things of that nature. So fiduciary insurance, as you could imagine, can really be a big benefit to advisors and plan sponsors.
Interesting. So kind of in the same line of that, are there some best practices and considerations a plan sponsor or an advisor can use when they're selecting their investment lineup for the plan?
Sure. And we offer a lot of that kind of information on our website. But just to give you just a few rules of the road, I think there's also another myth or, misconception that target date funds are the answer. So when you put a target date fund in the lineup, it's a set it and forget it type of approach, and you can just implement it and never have to look at it again. I hope everyone knows that that's not true. Target date funds, just like any other kind of investment, must be reviewed. Among other things, you'll want to look at the expenses, the glide path, meaning is it a target fund that's designed to generate tax-deferred growth up until retirement, which are called to retirement glide paths, or is it one that's designed to generate growth through retirement? And that all depends on the nature of the investments in the target date fund, and then making sure that they're aligned to the workforce of the plan sponsor. So if the plan sponsor primarily has younger employees, for example, maybe a glide path of the to retirement is better than through retirement. And so that's just one example of the kind of things that should be examined as well. Lots of different plans have default investments. And so those that do, there are special rules for those plans as well. And the investments that are part of that investment, the investment options that are part of that. And so the advisor should be examining the investments regularly to make sure that they comply with those rules as well.
And Allison, another question that we commonly get from a lot of our clients are, what is an investment advisor 321 versus a investment manager 338? And what's the difference for advisors?
Well, so those sections, just for background purposes, 321 and 338 just refer to sections of ERISA. And the difference really is the level of discretion of the advisor. So an investment advisor is there to make recommendations to the plan sponsor, but ultimately the final decision of which investment options to offer in the lineup belong to the plan sponsor. An investment manager is a little bit different. They're the ones who not only make recommendations, but actually go ahead and implement those investment elections as well. And so there are usually different fees charged because, as you could imagine, there's a different level of risk associated with fulfilling each of those different roles. But that's primarily the main difference.
Okay. Well, thank you so much for the clarification. So we're getting close to wrapping up the podcast. And one of the things that we're starting to do with the podcast is to throw in a generic random fun question that we ask our guests. And one of the questions that we came up with is, what would your superpower be and why?
Well, it depends who you're asking. If you're asking my children, I hope that they say that I have all the superpowers that I need. But relative to this podcast and topic, I would say really educating, especially younger workers, on the value of investing in your company's 401k plan. It's really amazing to me as someone who's more in the middle of my career, how quickly and effective that is in terms of tax deferred growth and setting yourself up for retirement. So I wish everyone just sort of had a crystal ball to be able to understand how small sacrifices early on in your career can really translate to preparing yourself for your retirement goals later on.
Okay.
It's very practical.
Very, very practical. So with that being said, Megan, I think we're close to wrapping up. Is there anything else you'd like to add?
No, I just want to thank you, Allison, for joining us today. It's been a pleasure. I know our listeners will benefit a lot from what you've shared today, and I really hope we can bring you back in the future to dive a little deeper into the topic.
Oh, that would be terrific. I'd love to. And we're so happy to help and educate your advisor audience on all of these different topics. They're so important to help plan sponsors really prepare for their plans and be able to make them the most effective for their employees and for themselves.
Fantastic. For our listeners, in our show notes, we'll have links to Vestwell's website so you can learn more about their services. We'll also have links to the DOL's website and training that Allison mentioned, and also have some additional information for you regarding just fiduciary basics. So please visit the show notes. We want to thank everyone for joining us today and hope you can join us next time on the RIA Compliance Collective. Until next time, we're here to get you there.
Thank you for listening to the RIA Compliance Collective. Your support is greatly appreciated. If you want to experience the RIA Compliance Concepts difference yourself, visit RIACC.io. From mock audits to customized compliance procedures, ongoing compliance assistance, and beyond. We're here for you always. Keep listening to discover more on how you can keep your advisory firm compliant so you can focus on achieving your goals. RIA Compliance Concepts. We're here to get you there.